All right. I think we're hitting this critical mass. So how about we go ahead and get started? Thanks again, everyone, for joining us and welcome. My name is Noah Parrish. I use he, him pronouns, and I am the communications director here at Gender Justice. And joining me today for our SCOTUS chat is Jess Braverman. Jess, do you want to introduce yourself?
Hi everyone, I'm Jess Braverman and I'm the legal director at Gender Justice. And I'm a bit
Awesome.
frazzled a lot. I had like this day cleared out to catch up on all this work, and that is a sure sign that a SCOTUS opinion's gonna come down. So
Me too. Me too. But I'm glad we made this work today. So today we're going to talk about that SCOTUS decision. This morning it was decision came down FDA versus the Alliance for Hippocratic Medicine, also known as the mifepristone case. So this morning the court unanimously upheld access to mifepristone, which is a crucial medication used in over half of all abortions in the United States. While today's ruling maintains the status quo for accessing mifepristone, it also contains some troubling language, suggesting that doctors with religious objections to any medical treatment could potentially opt out, even if it could result in death or severe harm to their patients, and even when there are no alternative providers to ensure care. So, this afternoon, we're going to dig into all of that, what happened, what it means, and what might happen next. We'll also save about 20 minutes at the end for folks to ask questions. But along the way, we encourage you to drop your questions in the Q&A function here in Zoom, and we'll get to them then. So with that, Jess, let's jump in with a quick overview of the case. What exactly was being decided in the case of the Alliance for Hippocratic Medicine versus FDA?
yeah, so what was being decided? That's like a great question. So there's two medications. They're the same thing. One's the generic mifeprex and mifepristone. So if you hear me saying mifeprex, it's not a verbal typo. Is there a word for verbal typo? I'm sure there is. It's not like a verbal typo. Like mifeprex was approved in the year 2000. Mifepristone is the generic. That was approved in, I believe, 2019. And so these pills, these medications are part of the typical regimen for a medication abortion. Mifepristone or mifeprex and misoprostol are medications given to patients. They take these medications, and that is how a medication abortion is performed. And so what happened was this group of doctors, I don't think they were all doctors, one might have been a dentist, I'm not sure,
I heard that.
challenged, yeah, challenged the FDA's approval of mifepristone and mifeprex dating back to the year 2000. And so when you ask me what was this case about, it's like hard to answer. It's like this case was about time traveling back to the year 2000, like before 9/11, before, you took your shoes off at the airport, before COVID, before, going way back in time and undoing the FDA's approval of mifepristone, which is not a thing, but it is something that they asked for.
Yeah. And can you say more on who brought this case and really what are they aiming to do?
So what they're aiming to do is they're aiming to have the court roll back the availability of mifepristone as much as possible. So they'd like it to either be non-existent, to just not be a thing that anyone can access. But what they're asking for is to roll back changes that the FDA made to uh basically over time the FDA has changed how mifepristone can be prescribed. It included telehealth over time. Originally, you had to go visit the doctor and get your medication in person. And so there's been a lot of um advances from, it's God, this whole thing is a bummer because these restrictions on mifepristone should have never been there to begin with. That being said, over time the FDA loosened some restrictions, allowing telehealth. So these doctors want to roll back the loosening of the restrictions. Basically, they're basically clawing at the wall, saying like anything to do with mifepristone, whatever we can roll back, that's what we want to do. And so that's what they're basically asking the court to do. And this nonsensical opinion got some traction in Texas. So yeah.
Yeah. Well, let's pivot to what happened today. How did the Supreme Court rule today, and what does that mean for folks?
So the Supreme Court basically maintained the status quo on mifepristone. What they basically said is, it's available, it's still FDA approved. The loosening of restrictions on availability, those restrictions are still loosened, so it's still available by telehealth. And so basically the big win, the thing everyone's excited about, like, yay, is that like we get to keep the status quo, and this completely bananas lawsuit was unsuccessful. Although of course it did cause like years of chaos and confusion, and made people unclear on what their rights are, made providers unclear on like, do I have to order different medications? So after causing years of chaos, the court found that the physicians and the dentist do not have standing to bring their lawsuit. And so that's not the end of the lawsuit, and we'll talk about that. But the bulk of the ruling was about standing, meaning someone's right to bring a lawsuit. So typically, especially in federal court, it can be a little different in state court, but to bring a lawsuit, you have to have a real stake in the outcome. Like you have to say, like, this impacts me, not just I don't like it, not just like it's a bummer, but like this impacts me in a tangible way that I can articulate. And the court basically said that the doctors here don't have that because they don't prescribe mifepristone. They don't, treat people who they don't have to do these things. They've never been asked to do these things, and they've never been forced to treat anyone who's taken mifepristone over their expressed objection. And so because nothing's happening to them, nothing has happened to them, nothing will happen to them, they don't have standing. The court was basically like, just because you don't like something other people are doing doesn't mean you can sue about it if it has, at the end of the day, nothing to do with you.
Yeah. So you said a minute ago, this case should have never come before the court. Can you explain why?
Yeah, it's just a wacky case. There's never been a case before asking a court to go back 24 years in time to undo an agency action. That's not a thing. Like I was a criminal defense attorney for 10 years, and when you're desperate, when someone's facing prison, you make up motions. Like if there's something that's going to get your client out, you just start fabricating like claims and stuff. But that's not typically how civil litigation works, and that's not there's no like doctrine of going back in time to undo an agency action 20 years later. So it should have just never happened, right? It should have been laughed out. In any other jurisdiction, it would have been maybe hopefully laughed out of the courtroom. But the doctors brought it specifically in this one district in Texas where they have a judge who's extremely sympathetic, who's extremely willing to entertain these wacky lawsuits and extremely willing to find standing where there is none. And that's exactly what happened here. That judge, Kaczmarek, rolled back, like kind of went along with almost everything they asked for, rolled things way back. But then the Fifth Circuit, which is the appeals court, one court above Kaczmarek, rolled that back a little bit, but still said, we're okay with some of these restrictions. The Supreme Court then put the whole thing on hold, put the status quo back in place until they decided, and that decision came out today. So basically, there was a little bit of chaos. The Supreme Court kind of put a temporary lock on the chaos for a little bit, and then today they reinstated the status quo. And so right now, it's like the lawsuit never happened in terms of how you prescribe it, its availability. That being said, the lawsuit is not over.
Mhm, mhm. So today was a unanimous decision. Does that mean there was a single opinion, or did any of the justices offer a separate concurring opinion?
It was unanimous. The only justice who offered a separate opinion was Justice Thomas, to just randomly weigh in that he doesn't think like abortion providers should be able to bring legal claims on behalf of their patients. Nothing really to do with this case. Nothing really to do with much of anything, and like not correct, like not what legal jurisprudence has been. It's really common. There's a whole legal doctrine about, whether and when doctors can bring claims on behalf of their patients and why. Thomas wrote just to let you all know he doesn't like it. And so that was his concurring opinion. There were no dissents, and the decision was unanimous. So he did sign on to the main opinion.
Thanks. So today was, a win, so to say, for access to mifepristone. So that's a relief. But from what I understand, the decision is a bit of a mixed bag. Can you say more about that?
Yeah, so I mean, just the fact that they entertain this and the fact that this is being framed as a win shows just how far like the Overton window shifted, right? Like this isn't like this really wacky and ridiculous lawsuit was not successful in rolling back a completely safe and effective medication that's been that was approved 24 years ago. That shouldn't be exciting. That should just be like, yeah, of course. And so in that way it's like very bittersweet. Like it's like, yeah, we won, but like we won what?
Yeah.
Practically speaking, yes, it's a big deal. I don't mean to minimize in that sense, but like it's a lot of our wins these days are actual bummers when you like stop to think about them, because it should just be the way things are. The other reason that I really didn't like this opinion was because the judges talked a lot about religious exemptions. So basically, there were a number of reasons why they thought the doctors here didn't have standing, but there was one that I found really troubling, which was essentially, doctors, they were kind of saying doctors who work in emergency rooms don't have a requirement to treat a patient if it violates their religious beliefs. And it was the language they used was really broader than how I would read any current federal religious exemption laws. I don't know, the reason I'm kind of hedging is because I didn't see a lot of opinions out there today that really touched on this, and I don't know why that is. It's possible they're all waiting. There's an upcoming case that directly is on point with the question of like what is and isn't required under EMTALA, which is a law that requires hospitals receiving Medicare funding to provide any patients who show up in the emergency room in need of stabilizing treatment to provide that treatment. That case is coming up, and so maybe folks are waiting to see how that plays out. I thought this opinion was really troubling. Like it's like, yay, we won because these doctors don't have standing because, according to the court, they can just let someone die, and so they don't have to treat the patient. And that for me is like worse than a like not status quo. Like that for me is horrifying, right? Like I'm reading this and I'm horrified. And so yeah, it's being touted as a win, but like I just had trouble. I read it, it made me a little nauseous, and I didn't really see it that way personally.
Yeah. So, I mean, they ruled based on standing, but from what you're describing, this means the court or a future court could take a case that does have standing. Do you have a sense of what that might look like?
Well, yeah. So a number of states intervened. Judge Kaczmarek allowed them to intervene. I believe it was like Idaho, Kansas,
Missouri.
Missouri.
Mhm.
Intervened, basically saying we intervention means like someone who's not part of the lawsuit says like this lawsuit directly impacts me, and even though I wasn't sued or I'm not the one who sued, I'm so interested in this case that you need to let me in. And those three states made that argument. um, and that ruling was the interests that they presented to me again were kind of ridiculous, but the court hasn't directly spoken on whether those states have standing. So technically the case is going to go back down, and we're going to see. So like this case isn't over. Um, but a lot of what happens when the court says you don't have standing is they're laying out why you don't have standing, which is also provides a roadmap for like, okay, well then who does? And so, yeah, someone else could bring the same exact lawsuit, and if they have standing, the court might get to the merits then. Oh, can someone mention? Yeah, so that's a good question. Can I read the question?
You want
Do
me?
you want to read the
Yeah,
question?
I can read it aloud.
Yeah.
So, as someone who's not a technical legal mind, me neither, can someone mention whether this religious exemption discussion could have any bearing on the EMTALA decision, or was it just justices leaving breadcrumbs for future suits?
I read the opinion. That's a great question. Because I wasn't seeing much chatter about this, and so I was wondering, like, am I like there's something wrong with me? Am I just on edge? And so I read it over and over again, and it looked to me like a unanimous decision of the Supreme Court is that individual providers. It's what's called dicta. So when courts some of the stuff courts say in opinions aren't necessarily like the law or binding. They're just things courts say, and they're like maybe persuasive, like some people are persuaded by them, but there's this confusing area of law where like you read an opinion, it's 500 pages, one paragraph or one line is the actual ruling, and everything else is just what we call dicta, meaning like it's not binding. There was a lot of talk about EMTALA in this opinion. And what the judges said was individual physicians are not required to provide abortion care under EMTALA. Um, I've seen conflicting agency guidance on this question. I've tried to look like, am I crazy? Because I didn't think EMTALA was one of the statutes that explicitly has a religious exemption like that. I know there's other federal funding that can't be conditioned on providing abortion care, but I didn't think Medicare, social service money was one of them. I may be wrong, but to me, I'm reading this and it looks an awful lot like they're not dropping breadcrumbs. They're saying, in terms of what their position is for individual doctors and EMTALA, that they don't think individual doctors actually have to provide this care. And it was kind of even worse than that. It was like, they weren't even like concerned, like, do you tell your employer ahead of time so they can plan? Like, what do you do? Like, it was just kind of like, you can just show up and say, I'm not doing this. And it was just, it was really wild to read. But the EMTALA case, which is the question, wasn't squarely about that. It had to do with Idaho's abortion law and whether there's a conflict between Idaho's ban on abortion and EMTALA. So like what happens if someone shows up, they need an abortion or they'll be seriously injured without it. Maybe they won't have access to future fertility if they don't get that taken care of. So under EMTALA, the hospital would be required to provide abortion as stabilizing care, but Idaho prohibits it. So what law wins out? And typically in life in general, we have this thing called the supremacy clause, where when a state law and a federal law conflict, the federal law wins. And so this shouldn't really be a question. Like EMTALA should win over the Idaho abortion law, but I am not super optimistic about that. So I don't know what the ultimate outcome of the EMTALA case will be, but I didn't like what I read in this case about EMTALA. So yeah, I just found the whole thing really troubling and really hard to read.
Yeah. So switching gears a little bit, unlike in the arguments, Comstock didn't come up in the decision. Could you give us some more context on this?
Yeah, the Comstock laws are these old laws written by, I guess, a curmudgeon who like didn't want anyone to have any sort of like fun. Like he was really against like smut and like, which is like everything smut, right? Unless it's the Bible. And so like he didn't want anything to go through the mail, the federal mail, that had anything to do that was like smutty or obscene or was contraception or abortion related. At some point, contraception was pulled out of that, but it still technically says abortion in the Comstock law. So right now there is a law saying that it's illegal to mail anything used to provide an abortion. That's typically like in a normal time where courts aren't being like this wacky, that's typically interpreted to mean like illegal abortion, right? Like you can't mail something to someone that's not actually like approved or part of the standards of care. Like it shouldn't be, it might actually ban. I don't want to be dismissive of folk medicine, but like it might apply to that, right? It wouldn't apply to stuff that's legally being sent through telehealth, let's say with a prescription to provide an abortion. It's an approved medication, right? That's not typically how folks have read Comstock over the years, but right now we're seeing a resurgence of this wacky law that's not typically been enforced. It's really outdated, and it at least plausibly suggests that it's illegal to put anything abortion related in the mail. Now you have to think about that, right? Like, do we manufacture mifepristone in Minnesota? If not, it has to be sent over to Minnesota. So that's sending a mifepristone in the mail, right? And so there's right now a lot of fear and a lot of questions about how broad is Comstock? What does it apply to? Are people going to be prosecuted under it? Most folks are not reading Comstock that way. Like, I don't want to freak anyone out. Like, abortion is still available. People are still providing it. People are providing it over telehealth. It's not a common interpretation of Comstock, but Comstock keeps rearing its head in Supreme Court arguments and in other places, and it is causing a lot of fear and chaos. And that's what a lot of this is about, right? Because as we always say, abortion can be legal to provide, legal to receive. but that doesn't mean people have access to it. Like if you think you're going to get arrested for having it, if you're a doctor and you think you're going to be arrested for providing it, that's really terrifying and it's chilling. And it means that regardless of whether it's legal, people don't have access to it. And so the chaos about Comstock right now is really in that genre of like, is it going to impact access? Is it causing fear? And is it just going to like rear its head in argument after argument at the Supreme Court to scare people? It'd be lovely if it was repealed.
What's the pathway to repealing it?
I know there's concern. There is, I think, really legitimate concern that if Congress tries to repeal it and fails, or like passes a law, no, like to repeal it, or passes a bill, right, a repealer, and then it fails, that courts say, well, it's basically revived, right? Like this outdated law that never is applied. You tried to repeal it, you were unsuccessful. That means something, right? Like that mean that, like we're going to enforce it, we're going to make it. So there is a fear of, I think, Congress failing to like trying to repeal it openly and then failing. That I think is a
Mm.
scary proposition for folks. Um, but yeah, it would need to be repealed and hopefully successfully repealed. So we'd need enough votes to repeal it.
Well, speaking of votes in Congress, is it possible for Congress to pass a law that bans mifepristone?
Um, oh, that's a really great question. That's like, yeah, some questions are like, I want to just say like, sure, why not? But there's all these wacky areas of law of like what's within the federal government's purview, what's within the state government's purview.
Mhm.
What if it's being banned for for a use that's constitutionally protected? Like, I don't know a simple answer. I will say though, like lawmakers can and do pass any law they want. And often those laws can be blatantly unconstitutional and they can still pass them. There's no rule that you can't pass an unconstitutional law. The question is then whether it'll be enforced. And I think it's another like chaos issue. Like, even if you could get a law like that enjoined, which I'm not sure, what does it do to people in the meantime? This chaos of like, is it legal? Is it not? What is this? So sure, I would say like they can do whatever they want in theory. They're pretty much immune from they're immune from like I think legal liability for the most part for passing nonsense laws, which is not fun. It's scary.
Talking about another nonsense law. I heard that Louisiana recently passed a law that reclassifies mifepristone and misoprostol. I'm not sure how to say that one as a controlled and dangerous substance. And other states might be likely to copy that legislation. Is that one that might be challenged in court as well?
Um, I mean we'd have to see because that challenge would come in. It would come in Louisiana. It would, whether it would be a state challenge or a federal challenge, I really don't know. I know that there are brilliant legal minds at like our friends at the Lawyering Project, at the National ACLU, at the Center for Reproductive Rights who do work on a national scale, who I'm sure, or I hope they always do, right? They always have creative challenges to laws like this. But yeah, adding so controlled substance laws, there's a federal one, and then each state has one. Minnesota has one. And oddly enough, like marijuana is like a very
Hmm.
serious, like it was Schedule 1 for a while, I think. It's the Schedule 1, Schedule 2, Schedule 3, Schedule 4, which is like how severely it's restricted, how severely it's treated if you are caught in illegal possession. It basically treats it like an illegal um drug. And I think what the point there is like controlled substances, if you can like some prescription medication are controlled substances and you're allowed to have them if you have a prescription. In Louisiana, if you can't have a prescription for mifepristone for an abortion, then you just are kind of out of luck there. And I know that there are groups, there are providers around the not around the country. There are providers in certain states who are, and I think this is so brave, like who are providing into states where it's banned. There are international organizations that provide, and so I think they're saying, well, Louisiana government saying, well, we banned abortion, people are still accessing it. How can we still stop them? And it's basically criminalizing people who have possession, and it's terrible.
Yeah. Well, folks, if you have questions, please drop them in. As we get to those, just is there anything I didn't ask you that you think is important for folks to know and understand about today's decision?
Just, I would say this is like the case isn't over. I would be really wary of getting excited about this. To me, this isn't a win. I think like it's easy, like if I hadn't read it, if I was just reading the news, I'd be like, oh, cool, great.
Hmm.
But like when you actually read the opinion, it's to me, it's horrifying. And um, you know, how much do you lose? Like, how much of your humanity do you lose in a ruling that says, like, we'll maintain the status quo? This lawsuit never should have happened. And also, like, doctors can leave you dying on the floor if their religion tells them to. Like, that's not good to read. Like, that's not good. And so I would just, just caution folks. And then I kind of see this as one of two. We're still waiting eagerly for the EMTALA ruling, which is the law we talked about before about providing stabilizing care at an emergency room. And so I think those two cases together are going to paint a stronger picture of issues around religious exemptions, whether we have any reprieve in banned states, like under federal law, to make sure that people get their abortion care. If you haven't already, I'd really encourage folks. This is written in like plain English. Center for Reproductive Rights filed this incredible lawsuit in Texas about women who went to the emergency room to get emergency care, which did require abortion care. They were turned away, and how horrifying it was for them. All the repercussions and what it felt like to basically like have to go into septic shock because you're being denied care that could be provided to you. I would highly recommend folks look at that. It's in plain English. And so like non-lawyers can read it and just get a real picture of what's going on in places where there's abortion bans and we're not able to get at least any federal level relief. But there are some questions in the chat if we want to.
Yeah, let's get to them. So our first one here is, does this ruling have any specific impacts for us here in Minnesota or indicate anything about the legislative work that needs to happen here?
Yeah, so there's been some exciting stuff at the Capitol. I know there was the law passed requiring insurance to cover abortion care. There was the amazing repealer that repealed. So like 5 years to the day in May 2024, we won our lawsuit challenging with the Loring Project, challenging Minnesota's abortion restrictions. Those were then repealed by the legislature. Repealing bad laws is so important. And I'm so glad our legislature got the message there. I would say it'd be really great for us to pass a repro inclusive ERA. That's something
Mhm.
that we were really pushing for this session, and we're going to push hard for next session. The thing about an ERA being repro inclusive is that if you just say, like, let's have an ERA with equal rights, like, okay, well, Texas has that, and look at what it looks like over there.
Mhm.
Pennsylvania passed a sex-inclusive ERA that was not specific about repro, and they eventually got there just this year, but it took 50 years of litigation for the courts in Pennsylvania to find that their ERA does cover and protect abortion. And that was after a loss, I think in the 80s, they had a loss on that, and then like the court reversed that loss like in 2024. And so we're not in kind of safe legal territory where you can rely on precedent or you can think courts are going to be reasonable. Like if you want a right protected, you have to be explicit. And so a repro explicit ERA would be fantastic. And, it's not about thinking like, well, we have abortion here now, so why do we need the ERA? It's like, okay, but will we have it in 50 years? Like we had Roe v.
Mhm.
Wade. And so
Mhm.
that's super important. And we're going to keep pushing for a repro inclusive ERA.
Great. Our
Equal
next
ERA is
question.
an equal rights amendment for those who
Yes,
weren't like
yes. Acronym
spending every day
breakdown.
of their life working on the ERA.
Well, we're dropping in the chat a couple links to learn more about ERA, so y'all should definitely check that out and sign up to get involved in our push in 2025. So our next question, how should Minnesota voters take this ruling and other conservative attempts to restrict abortion access into consideration in the upcoming election?
I so I love that question. Here's what I try to say to people, and this is like maybe my failing. I'm not doing a good enough job making this clear. Like it's not just abortion that's under attack, right? Like contraception. Like
Mhm.
I know people think like I say this and people laugh and they're like, who want like but Republicans use contraception. Like people laugh in my face when I say this, but contraception is absolutely under attack right now. What they're doing is it's a multi-pronged approach, right? So they're saying, no, we won't come after contraception. it's just that we believe that all of these things that you consider contraception are actually abortifacients, right? Like emergency contraception that works by delaying ovulation so that the sperm cannot fertilize an egg, right? But what the anti say is like, well, I don't think that's how it works. I think it prevents implantation of a fertilized egg, and I therefore think it's an abortifacient. So I'm not coming after contraception, but I am coming after emergency contraception because I don't believe it's contraception. Um, they're coming after IVF. Um, they're like they are absolutely like I think the biggest takeaway is to take judges, lawmakers, um, anti-abortion advocates to take them at their word. Like don't,
Mhm.
which doesn't mean like run around in a state of panic, right? Like abortion is legal in Minnesota. People can have an abortion here in Minnesota, but it does mean like just take people at their word and don't dismiss these very real threats that we're seeing. Like when I used to read a legal ruling and think like, oh, well, this is dicta, like whatever. Now I take dicta very seriously because it's basically the judges telling us what they're going to do, right? How many opinions came down where Alito and Thomas said there is no right to an abortion? There is no right. Leading up to Roe v. Wade, they said this like every day, and we were like, that won't happen. And then it did. And they told us it would. So my biggest advice leading up to the election is like, believe the things that people say they're going to do.
Yeah,
No,
we have a
they're coming
clarifying.
after IVF. They are coming after IUDs. So there's a question in the chat. Are they coming after IUDs or IVF? Did I misspeak? They're coming after both. So IUDs like absolutely is under that category, like emergency contraception of things that they are reclassifying. So they're saying like an IUD is basically an abortifacient. So we're not coming after contraception, we're coming after IUDs. It's just that we don't think of IUDs as contraception. And so yeah, absolutely IUDs. IVF, yeah, absolutely. They're coming after IVF. And so what the issue there is that with IVF is that there are a number of you know what? I'm going to embarrass myself because I looked at the list and there are medical care providers on this call. So let me just give the caveat of I went to an extremely religious school growing up. I was taught creationism and I had zero sex ed. If I say something wacky and you're a provider who like can fix it, like I will not be offended if you chime in. But the gist of the IVF issue is that there are a number of fertilized eggs that all kind of get, you know, a number of eggs get fertilized at once, and then some are selected and some aren't. Oh, thank you. Thank you, Dr. Hope. So like some are selected and some aren't. The ones that aren't may be destroyed. For folks who believe that any fertilized egg is like when life begins, even if it's not in a womb, those folks believe that IVF is akin to abortion. And so, yeah, they are absolutely coming after IVF. And we've seen in state legislatures around the country doctors, providers having to come to the state legislature and explain what IVF is and how it works, because I think this just happened in Idaho because they're trying to ban it. Um, what would be, oh, and someone asked, can you expand on this? What will be done differently in the future? Like, what are the legal challenges, you mean? I just want to make sure I get that question right. So whoever wrote the question, what will be done? Oh,
Oh, they're asking a question that we haven't got to yet, but let's go there.
okay.
The question was, why were we not able to pass the ERA this year?
Oh, that's like a question as hard to answer as like
I
what was
know.
the FDA case about. We did so much work leading up to the introduction of the ERA. We brought together groups of like some of like, you know, really smart lawyers, folks who advocate in different areas, right? Like folks who focus on race discrimination, disability rights, all kinds of areas. We came together and we said, look, we're in different legal territory. We're not where we were in the 70s. We're not even where we were like in the early 2000s. We're in this world where we need to like, if there's a right we want, we need to say it and not just leave it up to courts to interpret some vague flowery language. So how do we have an amendment that actually like says what it is we want? We put together this language. It's explicitly inclusive of the decision about whether to become pregnant, to remain pregnant, pregnancy outcomes. It includes gender affirming care. It includes like a whole bunch of different stuff, and it's explicit. We then worked with we meaning like Gender Justice and ERA Minnesota, like a number of groups, I believe Out Front, like a number of groups kind of came together and worked on educating legislators about why it's so important for the ERA to be explicit and that we can't just hope that judges will interpret our ERA to cover repro. We need to tell them to. Like, we need to just say, like, oh no, we 100% mean what we say here. And so there was, I think the legislators got it. We had some really strong advocates. We had people like texting at midnight being like, what, like, I have legal questions. Like, people were really into it. They were really engaged. They really jumped on board. The House passed it, and then the Senate ran out of time. The end of session was absolutely chaotic. If you want to maintain your sanity, maybe don't watch the videos from the last night of session. If you want to, like, I drive yourself crazy, do. It was absolute chaos. There were filibusters. It was complete chaos on the floor, and the Senate ran out of time. But we did have the numbers, and we
Mhm.
believe that we're going to keep pushing. The coalition, all of the groups who are involved are going to keep pushing, and we're gonna get it done.
All right, we have another question here. All right, I got to open this one up. It's longer. Hold on. What information, if any, do you recommend reproductive health clinics provide on their websites about the legal challenges to contraceptives and IVF? Do you think that reproductive health clinics should focus on providing medical information over discussing policy, especially when trying to earn trust in conservative communities? Or is it worth talking about legal threats to contraceptives and IVF, even if it colors the community's perception of the clinic's work as political rather than medical?
I think that's a fantastic question, and I think it really depends on it's such a I think it's a really personal decision. I was with some advocates in Idaho the other day, and they were telling me basically when IVF was under attack, an IVF provider who was actually pro-life, who was never really politically engaged or involved, showed up at the legislature and was like, look, I'm a Republican, I'm conservative, like, but I provide IVF, and I think I need you to understand what that is, like what it is you're banning here. And she apparently saved the day, and it was super effective. And so I think educating the public is important and effective. I think educating legislators is important and effective, and being a credible medical provider for your patient population is also really important. So I think it's a really personal decision. I think there's ways folks can help. I do think that a lot of education is needed on what IVF is, how it works, who gets IVF, right? It's a lot of people who get IVF. And I think that's why when the Alabama ruling came down recently, basically temporarily prohibiting IVF in Alabama, there was huge outcry because people across the political spectrum, across the religious spectrum, access IVF. The problem is it's this Overton window, right? Like, did you think 10 years ago that you'd be listening to a legal director jumping up and down, being like, they're coming after contraception? Like, no, it's everything's shifting. And if you don't believe they're going to do it when they say they will, you end up with like the Roe v. Wade Dobbs situation. And so it's not like today, it's not tomorrow, but there are bills in state legislatures seeking to limit IVF. There are bills about specifying about disposal of fertilized eggs in a way that would limit the ability for anyone to provide IVF. So it is important. The threats are real. The bills are really happening. The court rulings are really happening. Right now, IVF it's available in Minnesota. We want to keep it that way. And so that's another reason why the ERA is explicit.
Think that might have been our last question that I'm seeing. Do you have any final words, Jess?
No, just we really appreciate you all coming and taking such an interest in what's going on. I think the idea of people coming in engaged, people who know way more than me about how reproductive healthcare works. Like, I get so intimidated when I see you all here because I'm like, well, first there was Adam and Eve, like, I don't know what to say. But I really appreciate you all coming, spending your time with us, hearing us out, taking what we say seriously. Maybe you leave and say, oh, those crazy folks at Gender Justice think they're coming after contraception. But like, I do hope you leave, taking it seriously, mulling it over, and yeah, supporting the ERA is a great way to kind of protect us here in Minnesota. But we really appreciate you all.
Yeah, thank you all so much. And stay tuned as we wait for the EMTALA decision that Jess shared. So more information on that soon. So Thank
Yeah,
you,
we love
everybody.
us. We love a SCOTUS chat. There will be, as long as there's interest, we love doing
Yep.
them. So yeah, thank you all so much.
All right. Bye, everybody.